Good morning and welcome to the Countdown to POPIA Compliance webinar. I'm Ahmore, Brand and Communications Manager at Werksmans Attorneys. Thank you so much for joining us this morning, and I really hope you find this session informative, as we do pride ourselves in providing timeless thought leadership content, tackling issues which affect businesses and our country at large. In saying that, one of our core objectives at Worksmans is profiling our young and upcoming talent, just in empowering our future leaders. Candidate attorney Nico Matebula, whose passion lies within the data privacy space, will be leading our discussion this morning with our head of data protection and privacy, Director Ahmore Burger-Smidt. As you know, one of our key issues currently for organizations is the compliance of POPIA. As you know, the deadline's also fast approaching, which is 1 July, and we've been receiving many queries regarding how exactly compliance works and its application to various industries. We will be addressing these key issues during the webinar this morning and just assist you in navigating and understanding this process better. Please do send us your questions during the webinar. We will try to address as many as we can. However, those that we don't address, please do email it to us after the webinar. We will provide an email address for this. I now hand it over to Ahmore and Nico. Enjoy. Thank you so much.
Thank you, Howard. Good morning, everyone. My name is Nico Matebula, and I would like to welcome you all to this Werksmans POPIA compliance presentation. Our speaker this morning is Ahmore Burger-Smidt. She is a director in the competition department as well as the head of data privacy and protection at Werksmans. Ahmore is well renowned in a field of expertise for a deep knowledge and insight, and has advised both local and international clients on various aspects of regulatory law and compliance. This includes undertaking compliance audits and overseeing implementation programs, including policy formulation and rollouts. I will be your facilitator this morning. I'm a member of the Data Privacy and Protection practice at Werksmans, and I have the pleasure of working with Ahmore. Please do note that we will be taking questions towards the end of the presentation. And for that, I ask you to please pop your questions into the chat and we'll work through them and try to get to as many as we can. So without further ado, let me welcome Ahmore, who will be taking us through our topics for today. Ahmore, welcome. Thank you very much for giving this presentation today. I hope that people will enjoy it as much as we enjoy preparing for this and presenting it to them. We'll go into our first topic for the day, which from our engagements with clients and fellow practitioners, it has become clear that a firm educational foundation is essential to taking steps towards POPIA compliance. So Ahmore, could you please tell us about how and what we should think when it comes to personal information and processing?
Yeah, Nico, thank you. Indeed, it's a pleasure to have this discussion today with everyone around the table. We appreciate you joining us in our couch, on our couch, in our sitting room, and discussing these important things today. Because, you know, the reality is we're so fortunate as South Africans. We've got a constitutional right to privacy. And this piece of legislation, within 27 days, it's coming online. And we are expected as the business community to be compliant with the legislation, but it introduces so many complex aspects. And I think where we stand today, you know, the 27 days before the 1st of July, 2021, how are we going to deal with POPIA and the compliance with POPIA, taking into consideration that it's not the only piece of legislation that we need to consider, Nico, and as we know in our practice, you know, POPIA is intrinsically linked to POPIA. So if we look at the right to privacy and the rights we protected, one of the most important things in South Africa to recognize is the difference in our legislation to the rest of the world. In the rest of the world, we only look at natural individuals in terms of the application of the data privacy legislation. Here in South Africa, that right to privacy is afforded also to juristic persons, to companies. And if we consider on a daily basis what we work with and our engagement with our client base, one of the biggest issues we are confronted with considering multinational or global entities indeed relates to that interpretation of what does this right to privacy of juristic persons, the company having a right to privacy, what that means and how to interpret that. But just as important, where we stand and what we are currently focusing on is how to prepare for the 1st of July 2021, which is a massive issue. And what sets out that framework and what are the most important or crucial things we need to be thinking about?
Right. So on that note, Ahmore, I would like to get into some of the challenges that clients that you've dealt with and businesses that we've interacted with actually experience when it comes to approaching POPIA compliance, in the sense of what they need to do, but not only what they need to do, but what they actually need to know. As I understand, you have certain issues, for example, clients understanding their own processing in terms of their business and what they do from a day-to-day and how that actually fits in with POPIA. Issues of what to prioritize. As you mentioned, we're only about 27 or so days until the 1st of July, which is when the compliance deadline is. And we get a lot of these questions as to what do we prioritize, what should we know as a business in terms of processing information. I'd like you to touch on some of those ideas.
So if we consider data privacy and the application of the legislation, from our team's philosophy and approach, in the first instance is to realize that data is an asset. And if you sit on this massive asset, how do you protect it? But at the same time, in our engagement and interaction with our clients, we have to realize one thing, and it's a universal problem. It's not a unique issue to any specific company. It's just understanding where your data flows, where it comes from, what you do with it, where it goes. Because those simple things, if you understand those concepts, it actually informs the application of the legislation on your day-to-day business. And Nico, that is such an important thing to understand those processes, because we all think that we know exactly what we do. Why are you asking these questions if you're considering what we do as a business on a day-to-day basis from a practical point of view? Because people might even think it's a bit of a silly question, because we do it because we make money and we've got a business to run. So what are you actually on about if you ask these questions? But that refers to this concept of the life cycle of information. And if you understand as a business what information you've got, for what purpose you're using it, what is the reason, the business reason, and the core principles that you need to address through having this information in your organization, just understanding that simple process information flow through your organization, already you will be able to interpret and apply the principles, the conditions of data privacy legislation. Now, if we look at what are the biggest challenges, if you ask me that question, one of the biggest challenges is indeed organizations not understanding why they need information and what information they need. So if we look at the data privacy legislation, it talks to the whole concept of, you're supposed to collect only that information that is necessary to fulfill the function, and you hold on to that information for as long as you need to fulfill that function, offer that service, or offer that product. And once you don't need the information, you're supposed to then exit the information from the system. But we're so used to collecting a whole lot of information. And a simple example is just to think when people arrive at an office and they, we want to capture information because they have visited an office. What is the minimum information you need? Or fill in a form. Yesterday, we as a team sat with a form that we had to evaluate, and we wondered, but if this is the initial process or employment process in a company, why are we already asking for banking details and a tax registration number? We don't even know whether we want to employ this individual in that specific circumstances. So if you clearly think logically through the process, you don't need that information at that stage, but you might never accept this individual to work with you. And if you take it down to that core level, understanding what we're dealing with in the information becomes one of the most important aspects and one of the most difficult things to understand.
Yep, no, that's very true, Ahmore. And it's been my experience as well from working with you. Just businesses understanding their why, basically, as to why we ask for certain things, why we require you to give away certain information when you interact with us, whether it be in the employment context, whether it be customers, service providers, the list goes on. And that obviously speaks to the issue of compliance, because all you've described now is processing. There's businesses processing information and going through those steps. But then what that leads to is the issue of compliance and how people understand that concept to be, how they view it. From our experiences, we usually encounter situations where people say, well, it's compliance stamp, basically. It's the issue of compliance. And Werksmans coming in, assisting us with our processes, assisting us with our policies and all these things we need to have in place. And at the end of the day, they say, yes, they've done this process. Yes, they have these policies. They are compliant. Is that the way to think about compliance, or is it much broader, much greater than that?
And I think what links to that, because the question that we often get is, can you certify us as being compliant? Now, the question is, what is compliance? Is compliance a once-off process? Is it a tick box exercise? Is it 10 steps, and once you fulfill these 10 steps, you can say you're compliant, you can put it back in a folder, electronic folder, lock it up and walk away and never think about it again. And that's not compliance. That is not reality, because that means your business stopped. Your processing, what you do with information, why you ask for the information, immediately it's just come to an end. And it's such an important question to realize but what does certification mean? What does compliance mean? It is not a rubber stamp. We can every single advisor in South Africa can prepare a stamp and put it on a document and say, today we completed the compliance assessment, you are compliant. That means in that moment of time, you've got a level of compliance. Yes, we know going forward, because you're information officer, and I assume later on you'll ask me something about an information officer, but if we just think about that, the legislation says appoint an information officer. It's an obligation. The guidelines clearly stipulate certain duties of that information officer. So we can look at that to say, yes, we have to tick those boxes. So think about it like from an internal audit perspective. Yes, you can tick certain steps that information officer must undertake, and you as a company have to comply with it. That you can tick. But what do you tick when it comes to compliance? Because remember one thing, the legislation requires from us to demonstrate a reasonable level of compliance with the legislation. We've got this beautiful right to privacy that our Constitution guarantees. And, just to think, the audience can't see it, but right in front of us, we've got a whole mural here at Werksmans talking about the Constitution. And right at the top is the right to privacy. So it's a beautiful right that we've got, but that right must be balanced with all the other rights that the Constitution affords us. So it's not an absolute right. So if we look at privacy, I can't sit here, you can't sit here, Harvey's not here, no one in this audience has got an absolute right to privacy. It must always be balanced against the other rights. So if we look at POPIA, it asks for a balancing and therefore a reasonable level of compliance with the legislation. It does not mean we need to adopt or ought to adopt or think we can adopt a laissez-faire approach. The information regulator will require compliance with this legislation, but it is not a rubber stamp exercise as such.
True. And, as you were speaking, I was just picking up the number of times we use or come across this word compliance. This deadline has been thrown out at people, excuse me, for I don't know how long now, 1 July 2021, you must be compliant, you must be compliant. And if I'm sitting now as a person out there as a business, and I'm trying to approach this issue that is now POPIA, that's facing my business, I'm looking at this deadline, I'm thinking about this compliance issue. How do I narrow it down? There are all these things that I need to do to have in place. There's issues of policy framework, issues of procedural framework, and all these things I need to put in place into my business. And it all speaks to compliance. But now, how do I narrow it down in terms of a roadmap, so to speak, going forward, in terms of what my policy should actually look like? What does a compliant policy look like? And what does the process of compliance entail?
So I think it's an important thing that you raise that we all need to realize. What is this thing called a compliance policy? What is this thing that the guidelines, information officer guidelines, refer to as a manual? Remember in POPIA, we used to a POPIA manual, but now we need to stop and think about a couple of things. POPIA, it's got no exemptions or carve-outs for small businesses or medium-sized businesses. POPIA applies to every single business. That's an important thing. Where we currently got exemptions in place until the 30th of June in terms of POPIA, that exemption expires, and we're waiting for the information regulator to finalize the POPIA guidelines. But somehow these two roads must converge in terms of a manual, because it's an obligation to have a manual in place. That's one thing. Then at the same time, we know, and internationally also, we see privacy statements, privacy policies being made available, because that actually tells your data subject, how do we process, how do we deal with the information? Now, what is the problem sometimes? Clients would ask us to comment and evaluate their privacy statements and privacy policies, and we'll receive a policy that's actually just the legislation reflected in different words, in different terms, almost like in a plainer language format.
Yes.
So we actually look at the act to reflect the act, just in other words, and think, now I've got a privacy policy. Can never ever meet the requirements and the standard and the expectation of the legislation. Because why do you have these manuals of privacy policies and privacy statements? Those are there to communicate clearly to your data subject. What information do we need for what reason? What will we be doing with it? Where will it go? When will we delete it? And how can you then exercise your rights? So a privacy policy is not a copy and paste exercise from someone else's document. A privacy policy must speak to your business. So think about it like that. You need to speak to your business. Coupled to that, or clearly connected to it, and it was actually on the previous slide in the presentation. Everyone knows there are certain steps to take. If you look at compliance and creating a compliance framework. And those steps are actually standard. But at the end of the day, where we are today, 27 days before this legislation or the information regulator will start enforcing the legislation, we need to think, if you haven't done anything to date, what are the core most important issues? And that's back to your question, that's what you asked me. If we look at the core issues, we need to think, if we look at our business, how are we potentially exposing or not complying with the rights of the data subject? That should be the first thing you think about in terms of now putting in place. What is that privacy policy? Can we apply what we do on a daily basis and reflect it in our privacy policy to understand that? But more important, in my mind and in our philosophy, Nico, is empowering ourselves through knowledge and education. train, train, train. Because if we don't know what we're confronted with, how will we know how to apply it? So in my view, the first core aspect you need to deal with in terms of your compliance journey is actually to empower yourself through knowledge. And that is one of the biggest problems we've got. And, it takes us back where we sit this morning, right to where we started this conversation. Those concepts applying natural persons, individuals as data subject, but also companies got the right to privacy. Understand through education what that means and apply it to the business. So if we sit here today, the core pressing issues to attend to is how do you empower yourself through education to understand what the legislation actually entails, and linked to that, understand how we communicate to our data subjects to allow them to exercise their rights. And then there are a few other things, because it's compulsory. We can't pick and choose and decide what we want to comply with. There are certain things that the legislation says you need prior authorization for. If you need prior authorization, you need to understand what information you're dealing with on a daily basis that you require to keep your business up and running. And if you understand that, you need to apply to the information regulator for that prior authorization. It's an absolute requirement. You need to do that. So there are a couple of things, training, and how do we communicate to our data subject? What do we need prior authorization for? Address that. These are the things that you need to know. It's going to stick and you have to comply with it and address that. And you've got 27 days to address it.
Of course. And actually that brings us to what I think is fair to say has become somewhat of a contentious issue recently. It's this issue of the information officer, of course, because that is the person tasked with being responsible for compliance within an organization. It's this issue of information officer. And I just want to get into that for a bit and just discuss some questions we get is, do I need an information officer? Can our legal person who's already within our structure, within our company, serve that role? I just want you to touch on that and maybe provide some clarity with regards to the information officer.
Sure, this is such a hot topic at the moment, and how we deal with it and how we think about it, because we are now joining the Promotion to Access to Information Act and the Protection of Personal Information Act under one umbrella. And it talks about this role, information officer. Now, if we look at the role and the definition of an information officer, it means the head of the organization, the head of the legal entity. And that's also where the guideline starts off by saying, but that is the information officer, but you can delegate this to a different position, which brings us to two very important things. Number one, so who in the organization must be appointed as this information officer? And our experience is that, people are running for the hills. No one wants to take up this massive responsibility, because it is a responsibility. Let there be no doubt. And you will be held responsible for the compliance with the legislation. And I'm specifically talking now about the Protection of Personal Information Act. So if we look at that and if we consider that role of the information officer, we can't say there's an ideal or specific role or function. Should it be IT? Should it be HR? Should it be legal? The reality is we need someone in the organization that's got the ability and the capacity to understand what the legislation is about and how it impacts on the compliance framework within the company. Now, here in itself lie a bit of a problem in a sense that because the legislation doesn't carve out or exempt smaller companies, it means that even if you, a sole proprietor, you also have to comply with this legislation. So, you'll be the proverbial cook, dishwasher, and how does it go? You'll be doing everything because inevitably you'll have to be this information officer as well. But linked to that, so say for instance, you're part of this multinational entity. Who then is the information officer? The guideline says it must be an employee of the company. So if you're a registered legal entity within South Africa, you are expected to appoint an information officer, and you can appoint a deputy information officer. But every single legal entity in South Africa, number one, is supposed to have an information officer. Yes, for some it will be a massive burden, but that is the legislation we've got, and that's how it currently stands. So we need to know this. It's not optional. But part of what we're grappling with is now we've got a data privacy framework for a multinational company. The question then is, they've got a data protection officer sitting in Europe. That person is actually giving the direction in terms of compliance with all data privacy legislation. So we can't only appoint a deputy information officer in South Africa because our legislation requires that you appoint an information officer and then you can delegate or designate a deputy information officer. And that brings or introduces a level of tension in global entities or multinational companies, because from a GDPR and the European perspective, the information officer role in South Africa is very much similar to the data protection officer role in Europe. And there's an intrinsic conflict in an organizational structure if we introduce both these roles. And that we'll have to figure out and sort out. But as our legislation stands, irrespective of the fact that you might have a data protection officer from a GDPR perspective in Europe, in South Africa, you have to appoint an information officer as well. And the fundamental core interpretation of that is, if you're a legal entity, a registered company in South Africa, you need an information officer.
I suppose it's something that we will flesh out as we practice and implement POPIA. I just want to go back to something that you alluded to earlier when you were addressing this issue of information officers. And it's this thing of how POPIA is now under the same umbrella with PIA, especially in terms of the concept of an information officer. I want to touch more on POPIA's relationship with other groups. For example, we have the new Cyber Crimes Act that was just signed into law just the other day. We have the Competition Act, for example, and of course we have PIA, as you mentioned. I just want to go into some of how those other laws relate with POPIA and how those can overlap in some instances.
Because, this is such an interesting concept because the whole world is getting together if we look at this, and it's an ideal world for where the two of us sit and what we do on a daily basis, because we love what we do and it's intriguing and it introduces wonderful legal concepts. But we can debate it and love it, and our clients might see it as a compliance duty and burden. But if we pull all of this together, no piece of legislation stands in isolation. We need to look at the whole legal landscape for that we need to comply with. And the cyber bill, cyber security is such an important thing. And we've had the president sign the cyber security bill into law. It's an act now, and we're waiting for the promulgation, the date to be promulgated when it will be officially be enforceable. And without that piece of the puzzle, it's like we're building this massive puzzle. Without the cybersecurity side, we're actually lacking in our ability to partake in the global economy and the fourth industrial revolution. So we have joined as a jurisdiction, as South Africa, the bigger world in terms of now having robust legislation in place to deal with cyber criminals and cyber attacks. Because if we talk about a data breach from a POPIA perspective, most of those breaches, well over 50%, relates to cyber attacks. This is the new world we live in, the new world we function in. So without cyber legislation, we've lost one limb. We can't properly function. The same if we look at competition law. The whole concept of big data, artificial intelligence. What do you need for artificial intelligence? You need data. Where does that data come from? It comes from people, from human beings, that we collect the information, and in our terms of our POPIA legislation, also from other companies. So, we need that information to understand it, to analyze it, to interpret it, to create value out of it. So we can't leave out of the spectrum, how competition law can influence POPIA and how it links to also to then the Cybersecurity Act, and then we've got POPIA. And if just the concept of, what people might wonder, but why are we linking the Promotion to Access to Information Act with the Protection of Personal Information Act? Because both those pieces of legislation addresses a core aspect relating to the right to access to information. So as a data subject in terms of POPIA, I've got a right to understand what information of mine you hold, what are you doing with it. I have got a right to say I want it updated. I've got a right to say I want it deleted. At the same time, we all as citizens in this country have got a right to certain information, access to information that companies hold. So that all brings it together. So you can never look at POPIA in isolation. You can never look at the cyber legislation, Cyber Crimes Act in isolation. We need to think about this in a holistic scheme, and how do we apply it, and how do we engage with these concepts from a broader legal framework perspective.
And just for the benefit of those who may not know, you touched on the issue of cybersecurity and how that links with POPIA, the issue of data breaches. I'd just like you to discuss that concept as to what it actually means, what it can constitute, and some of the threats that come from that. Obviously, security safeguards is one of the conditions for lawful processing in the Act in POPIA, and it basically says that as someone who processes personal information, you must have adequate measures in place to ensure that information is secure, its integrity is preserved. And so it's clearly a very important aspect of the legislation. It's part of the protection of personal information. So I'd just like, for the benefit of those out there, just to understand this concept a bit better and how to think about it.
Yeah, so if we look at, data breaches and the fundamental principle from a POPIA perspective, and this actually forms one of the areas that you need to consider at this stage. How do you keep your information, your data secure? Because a data breach in itself introduces an immediate risk to a company's reputation. Besides the fact that you have to report it, you've got a reporting obligation to the information regulator. So how are you going to engage with the information regulator the moment you're confronted with a data breach? But most of the breaches actually occurs in an electronic form. It's an outside attack or internal technology failure in the process. So what are the measures? Is it a firewall? Is it encryption? Is it ISO certification and compliance that you look at from an electronic perspective to protect your information? A data breach means that you're going to lose the trust of your customers, of your client base. Inherently, that happens. How do you recoup that, and how do you build up, and how do you actually ensure that you can minimize that risk? I think it is internationally accepted that nothing is perfect. We don't live in a perfect world. Unfortunately, that is the reality. And cyber criminals will try and gain access to information, because as it's got value for a company, and when I spoke about artificial intelligence earlier, to use that information from an artificial intelligence perspective, people sell data that they obtain, and that's why we've got this thing called the dark web. Now, the information regulator can take significant steps if you've experienced a data breach, and you have to communicate immediately to your data subjects. Remember one thing: if you lose data, if you're confronted with a data breach, the reality is that you will have to tell your data subjects about this for them to be able to protect themselves. So it's out in the open. You can't hide it. You can't deny it. And what we are experiencing is an increase in data breaches for ransom. So it's blackmail. So if we say, you've got a bigger landscape, legal landscape that you need to think about data privacy against, the Cyber Crimes Act is so important, because not only are people trying to gain illegal, unlawful access to your systems from outside, they also are blackmailing you to get your own asset back. But we often in the world we live in, and I, sitting here, and you young men, I'm more advanced, let's be nice and say that. But looking at this, the world younger people live in, you live in an electronic world, which often means that we forget that we've got paper as well. So don't think that it's only electronic records. It applies to the paper records we've got as well. And how do we actually guard that? And in our experience, talking about compliance, clients often forget that they need to secure their physical records as well. So think about, how do you lock that room? How do you lock that filing cabinet? Have you got access control? Or can anyone just rifle through pages and documents in your filing systems? These are such practical, logical things. But I think the message today ought to be that if we talk about compliance, just sit still and think about, what have we got in terms of personal information? Where does it go? Where do we keep it? And how do we keep it safe? Isn't that the core, simple message at the end of the day?
Well, Ahmore, I think that takes us to the end of our presentation. Sadly, we wish we could speak on and on and on, but we'd also like to engage with you. What we're going to do now is start taking questions. So I ask that you please pop them into the chat. I'm going to work through them now, and I'll ask Ahmore some of the questions that we pick up here. Thank you.
It feels like I'm being cross-examined now, Nika. So this is...
So we have one question here from Andrew Maspero. Where does POPIA sit in terms of organizations such as data gathering organizations like Facebook? Facebook is not going to change its processes and will utilize personal information going forward.
So, Andrew, I don't really agree with you thinking that, they'll do whatever they want to going forward, because we do have POPIA now, and our information regulator, we know we've read about it in the media, have engaged with Facebook in terms of certain aspects already, and especially the breach that we experienced last year. And they extensively engage with Facebook. Now, I want to remind you that Facebook is a legal entity, registered as a legal entity in South Africa. So there can be no doubt that the POPIA legislation applies to them. And if the legislation, if they domiciled in South Africa, because that's one of the core tests from a POPIA perspective, the legislation applies. Therefore, the information regulator can approach, and I assume will approach, Facebook if they are transgressing the legislation, to actually amend their ways and to guard this right to privacy that we have got as South African citizens, as individuals and data subjects, and for Facebook not to trample all over people within South Africa, but to give credence to the right to privacy we've got and the legislation.
Okay. And we've got two questions that I've picked up here on information officers. I do think they require some clarification. So I'm going to ask it as a twofold question. One is from Fanny van Viljoen, and the other one is from Luan Smale. So Fanny asks, as far as I understand, the legislation appointment of the information officer is automatic. as the head of the private body. So the head of the private body is regarded as an information officer, and the function, unless the function is delegated. The only requirement for action is to register the information officer with the regulator. What are the consequences of not registering an information officer? And the other question is, should an information officer be a standalone position or a portfolio under IT or HR or the executive?
So, Fani, you're 100% correct. It's the head of the organization, except if you delegate it. So we've got two concepts: delegation of the roles and the functions of an information officer, and then designating to a deputy. So bigger organizations, you need a deputy because there will be a lot of aspects to attend to, and you need them to deputize it. But we raised it earlier in the discussion. So is this an IT exec or equivalent senior person in the organization that we appoint, or an HR person that we appoint, or legal person that we appoint in the role, or then delegate those functions to? We can't say that to you because it's organizational dependent. It depends on your company where that role will naturally fit. Now, the question is this a standalone position? In some institutions, yes, it ought to be a standalone position, where there are massive amounts of data being processed on a daily basis and a massive client base. So depending on an organizational, the size and the risk and the amount of personal information they process, this might very well, from a risk management and compliance perspective, constitute a standalone position, but not necessarily and always. So it depends on the specific organization whether that is a standalone position. Sorry, can we just get to the functions? I forgot to answer that question. And I think Fani asked that as well. The head of the organization, and then you can delegate it. The appointment, yes, at this stage you have to register that person. But Fani, I don't think you can only look at the registration in isolation. If we read the guidelines, and it links to the legislation, because the legislation says the further duties will be explored in guidelines, and those have been gazetted. And it also links to the GDPR. If we look at the DPO function in terms of the GDPR, the guidelines clearly stipulates aspects that your information officer will be held responsible for. And those aspects means that this is not only a registration process and stand back and don't worry further about the issues and the concepts. In fact, that duty in a large extent in the first instance require what we spoke about earlier: train, educate, empower through knowledge, that function, but in a bigger sense, the creation of a compliance framework, because that will be required of your information officer. What is your compliance framework? And again, if we talk about a compliance framework, this is not a one-size-fits-all. This is not a cookie-cutter approach. It depends the same as who in the organization will be that information officer. That compliance framework depends on your organization, what you do, how you process information, and the amount of personal information you process.
Thank you for that. And we have another question from Hendrik Cronier. Asks, hi, working in a medical practice, can we point a patient to our website where we list our privacy policy, terms and conditions, etc.? Or must the patient physically sign each document and must be provided, so the document provided to the patient?
Sure, Hendrik, that is a detailed question that you're asking. So in the first instance, you can point to your privacy policy, setting out, how you deal with personal information, what you collect, and the principles is reflected in your privacy policy or your privacy notice, privacy statement. People use different terms for this. So yes, you can point that, and you needn't hand out a privacy policy in printed format to every single patient that walks through your door. But you've got an additional aspect from a POPIA perspective, which you very well know, and that's why you're on this webinar today as well. And that's the fact that you deal with special personal information, that health information you deal with. And you know, the moment we are considering special personal information, it comes with additional responsibilities. Your threshold for compliance is higher. Therefore, when a patient signs up with your practice and that form that they'll fill in, that form will have to be, or adjusted or reflect the POPIA requirements in that form, especially in relation to the handling and the management of health information.
Okay, Ahmore, I know this interest will particularly interest you as you've dealt with it and grappled with it in recent weeks. Anonymous attendee asks, for entities with many subsidiaries, is it possible to appoint a single information officer for all these entities, even if the information officer is not formally employed by the individual subsidiaries, but is employed by the holding company?
Sure. So Nico is correct. We have grappled with this issue because it's such an important issue. And I think, is it Fani that asked the question earlier on about, you know, the head of the organization and delegate? It all links to this debate. And I think it's one of the most debated issues at the moment. Because you would, from a cost-saving perspective, want to appoint one information officer and they maybe have deputies. And also from a compliance burden perspective, it just sort of makes logic sense if you're a listed entity that the parent company will appoint the information officer and then every other subsidiary will have deputy information officers that report into the main holding entity's information officer. And yes, Nico is correct. We desperately wanted for that to be the case. But that is not what the legislation and the guidelines stipulate. So, and the information regulators approach. So the information regulators approach at this stage is that every single legal entity, if you're registered as a legal entity, you are required to have and register an information officer, which leaves us in the unfortunate position, and respectfully, I mean this towards the regulator and the legislation, that we will have to engage with the information regulator about this, because now from a POPIA perspective, and I'm only talking about this issue from a POPIA perspective, it is almost nonsensical that you have to appoint, if you've got 50 subsidiaries, each and every single subsidiary must have its own information officer reporting into your information officer on a parent level. But unfortunately, currently, we have to say that is how the information regulator interprets and applies the legislation.
I've got a similar question here from two different people that I'd like to address. One is from Michael Janssen van Vieren, and the other is from Derek Alexander. So Michael asked, do dormant companies or closed corporations need to comply as well? And Derek asks, practically speaking, it seems unreasonable to apply POPIA to SPY or shell type companies, such as a personal holding company for one's shares or investments, where there is no business as such. Same for security SPYs in lending arrangements. SPVs, my apologies, SPVs. What is the compliance burden on those entities?
Now, Derek and Raymond, I think you put your finger exactly on the point that we have been raising, and that we are engaging and attempting to engage with the information regulator on. Because yes, our view is also that it's nonsensical. Because on a cold letter of the law, reading the legislation, you have to appoint this information officer, but you're dormant. So, you know, who do you actually appoint and why and for what reason? So we have to engage with the information regulator further on that. And then we also need to consider, you know, from an exemption perspective, whether we can rely on it. But I do believe the way the guidelines have been written and how the guidelines have been presented at the moment, there are unintended consequences that we actually have not taken into consideration. And part of it is this, can I say, mingling of POPIA and POPIA, and the fact that we're heading to the 30th of June this year, where the exemptions for POPIA will become extinct, and there won't be any further exemptions, which means that there will be a blanket application of the legislation. And these aspects will have to be addressed with the information regulator. And I hope that in time there will be sanity will prevail, because it is problematic in terms of a letter of the law application, and it will be nonsensical for the regulator to actually embark on action against these entities. And one will have to argue that, you know, if I look at it also, one would, the information regulator has got a very slim task force that actually has to deal with all of these issues. So I do believe there's responsibility on us as the legal fraternity to engage with the information regulator and to help to think through these issues. Because yes, I can't but agree it is problematic.
Okay, so we've unfortunately got time for one more question. There's one that I've picked up here from Harvey. Harvey says, "Hi guys, thanks for the informative webinar. Please assist with my questions. One, as a company, we have obviously gathered lots of personal information over the years. Must we get permission from those data subjects? If so, it would be a mammoth task. Any tips or suggestions? Number two, all of us have emails, emails of customers, colleagues, etc., contact details, and on our electronic devices. If an employee's cell phone or laptop gets stolen, is it a reportable event, even though the data is password or fingerprint protected?"
Yeah. Sorry, I forgot the first question.
So about the information that the company has gathered over the years.
Over the years, yeah. Harvey. You know, a lot of the work we currently assisting clients with and giving guidance on is on this point. And let's think about it from a marketing perspective. We know of companies only embarking on an exercise now to clean the information that they've got on record. Because also remember, you can't engage on this concept of unsolicited direct marketing if it's not a customer or you don't have the consent of the individual to market to them. So at this stage, you need to think about ways and means that you can ensure that you've got a lawful basis for processing the information. Now, consent is not the only lawful basis for processing of personal information, and this is a big high horse of mine that I always get on, because we sort of accepted that you always need consent, but you don't always need consent. If you've got a legitimate interest to have the information, to hold on to the information, to use the information and process the information, you need not have consent. Again, why it is so important to understand what we're doing with our information and why we have it. But historic information, we have to spring clean a bit. And the question is, how do you spring clean? How do you clean that information you have? Then the concept of, employees having devices, their work email on it, having, iPads, iPhones, laptops, and all the rest. The concept that we're talking about is bring your own device to the office or bring your own device to work. Companies have to consider those policies, those security measures they've got in place. Because yes, it is a data breach if you lose the information and you have to report it, because that is your company's personal information. So the fact that it's a personal device doesn't carve it out, because the device is used also from an employment perspective. So what are your policies? And we all have to think about it. We spoke about initially, think about your privacy policy, but there are all these add-on aspects that you need to consider. I hope that answers your question.
Well, thank you very much, Ahmore. That brings us to the end of our webinar. I'd like to thank everyone that participated today. We really do appreciate your attention, your time, your eyes, your ears. Thank you to everyone who's asked questions. I think it's contributed to the webinar and everyone's knowledge and insights. For those who we weren't able to answer, we do apologize for that, but time constraints do not allow us. Please do engage with us further through our website. We've got lots of legal insights and opinions on there that you can refer to. But for that, thank you very much for joining. Thank you, Ahmore, for all your knowledge and your insights. I really did enjoy this. And thank you to everyone. Yes.
Yeah, just from my side, thank you everyone for attending. We appreciate our clients logging on to these sessions. We will be having a number of these on the couch discussions going forward, and we'll notify you. And I think today I'm very proud as Werksmans and as part of the Werksmans family to know that we've got young people coming up through the ranks. And Nico, congratulations. You were excellent, and I believe our audience will agree with me. And thank you, Harvey, and everyone else from the marketing team, and most of all to our clients. Thank you for attending. Have a good day.